Can't hear you, Brian.
How's this? Testing, testing. Hold on.
There you go. There you go.
Testing, testing. Good now?
Yeah, we got you.
No, man, always a technical difficulty. It's crazy. Testing. Still good. Still good. All right. So if I go blank at any moment, just y'all like you did. So we went a long time on mouth movement. No one said anything. So next time, y'all jump in quick. Thank you. All right. So tonight we're going to talk about 1692 E8. And then I have a case. We're going to do a case review. We're going to look at a motion for summary judgment that a debt collector filed trying to avoid an E8 case, and it has a lot of good language in it where you can actually learn from. How's my volume?
It's going in and out, up and down.
Oh, okay. Well, that's not good, y'all. Okay, that's not good. Hold on. Let's disconnect this mic, put it back. One second. Testing. Testing.
Seems stable now.
In and out. Testing. All right. So once again, if you at any moment we have any in and out, it should be perfect. So any moment it goes out, y'all let me know. It should not be going in and out. I'm not sure what's wrong. Okay. So at any moment it does it again, let me know and we'll try to get it fixed. So yeah, so tonight, 1692 E8. And we're going to go over the statute first. And then we're going to jump into that case. The case. Oh, here we go. We're going in and out again. Testing. All right. I don't know what's wrong with the mic tonight. We're going to go over the statute. Testing. Okay. We're going to go over the statute. Again, y'all let me know because I'm I can hear. And then we're going to go over this case. The case, it's not too long. We should be able to get through it. But it has a lot of good information. It's going to really teach you about E8. We've talked about E8 before, but we're going to dive deep into it with this case to help you understand it better. So let's review 15 USC 1692E, and then we're going to go down to 8. And this, of course, is a part of the FDCPA. All right. At any time, if you have any questions, just unmute, or you can raise your hand, use the hand raise signal, and I'll jump to you. But 1692E starts off, a debt collector may not use false, deceptive, or misleading representation or means in communication in connection with the collection of any debt. A debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt. Okay. Without limiting the general application of the foregoing, the following conduct is a violation of this section. Can anyone tell me what it means when they say without limiting the general application of the foregoing? Anyone know what that means?
I believe that means that where it specifically says and it's not included. Not included, but not limited to.
Say it again, Tony. Say it one more time, Tony.
I think Tony froze up.
Okay. Tony, I think we heard you say two things, and I think the last thing was the net, but I think you're frozen. Mountains. Anybody else want to take a stab at this one? It says without limiting the general application of the foregoing.
Is he really low for anyone else?
I'm low.
Yeah, Brian, you're low.
Yeah,
Yeah, you're low.
All right. All right. I'm going to mute for 2 seconds and play with this.
Roger that. It goes low when you start talking. It goes in and out. High, low, high, low.
Okay. All right. Looks like it's, hold on. Testing. Oh man, looks like it's testing. Okay.
We can hear you. It's just
Testing.
a consistency. You just go high, low. We can hear you now. It's just a consistency.
All right. We got low again, didn't it?
No, not this time. I mean, I can hear you. I mean, it's just
Okay.
consistency. Sometimes when you start talking, it'll go high, then it'll go low.
All right.
High, low.
Man, I do apologize. First time we've done this, of course, because. Okay. All right. Testing. All right. Looks like it. So yeah, if it does again, let me know. So without limiting the general application of the foregoing, anybody knows what that means? All right. I'll tell you. So basically, what that means is this first sentence of E8 is the general, is the particular statute. What they do here is give you a list of 19 examples. Okay. And so when they say not without limiting the general application of foregoing, what they're saying is we're about to give you 19 examples. Don't think that section 1692E is only limited to these 19 examples. It's not. But we're giving you some specific examples that are violations of 1692E. Does that make sense?
Yes.
So when when you say, look, you're in violation of 1692E for doing XYZ, that's not listed. That's not listed as a violation. Okay. Well, that's when you remember what I just told you, say, well, hold on, my friend. We're not limited to the 19 examples they listed. Read the first sentence of the statute. That's the law. The second sentence clearly tells you we're not, just because it's what you did is not listed in the 19 examples, means you're in the clear. Got that?
Got it.
And be sure to add the my friend part, because that'll make them feel little. We want to make them feel little.
Crystal clear. Crystal clear.
So without limiting the general application of the foregoing, the following conduct is a violation of this section. So, okay, once again, this is not everything that's a violation, but if they do this, it's a violation of E, 1692E. So we're not doing these others today. Tonight, we're focusing on 8. Doesn't mean any of those others are not important, but tonight we're talking about 8. Okay. 8 says communicating or threatening to communicate. Okay. Remember those ors, either or. Communicating or threatening to communicate. Okay. Can someone give me an example of communicating? Okay.
Electronic, email, mail, FedEx,
Right.
writing, all that.
Okay. What about threatening to communicate? What's an example of that?
Same thing.
Well, nope. It's a threat to do those things. So all the stuff you listed, but it's a threat to do it. It's not actually doing it.
Okay.
All right.
Okay.
So that's the difference. I want to make sure. I'm glad I said. So communicating is one thing. Okay. Threatening to communicate is another thing. Threatening is threatening or saying that you're going to communicate. All right. Clause says threaten to credit report. That's correct. So communicating or threatening to communicate to any person. What's a person?
Corporation.
Okay, that's
Credit
true.
bureau.
That's true.
Credit bureau,
Oh,
and it-
okay, hold on a second. How much we go find the judge, the section of the judge? All right. All right. Well, the CFPB is a person. So you're right. You're not wrong. Okay, what's another person? So corporation, person, bureaus, consumer reporting agencies, which are not the same.
Right.
But is Judge Parsons a person? All right.
Define that. It all depends on what the definition
I was gonna
states.
say it depends on
Person is.
what you referring to.
Person does not depend on what I'm referring to. I'm referring to the word person. So person, definition of person has no dependency on who I'm referring to. As the definition of person doesn't change.
So in the legal matter, I would say yes,
yes.
he is a
So
person.
yes.
As defined, yes, he is a person.
Yeah, absolutely. So a person can
Just
be
as corporations are. So
right. And just as a review, y'all, there's only 2 types of persons. Can anyone tell me that?
corporate, non-corporate.
Well, a limited liability partnership is a non-corporate, so I don't like that definition if you want to use that, because corporate is incorporated. LLC is
Okay.
not corporate. Limited liability company is not corporate. Limited liability partnership is non-corporate. So I don't like that one. Try again. You close. I see where you're going, but let's okay. Natural incorporation. Okay, that's what Quad says in the comments. So once again, that's not okay. So all right, that's not the 2 types. Natural, okay, I'll take that. And corporation, no, because a limited, my law firm is a limited liability partnership. That's not a corporation, but that's a person. So that's not correct. So the natural part is correct. But what's the second kind of person? You have a natural person, and then what other kind of person?
Unnatural.
Artificial.
Okay, well, we wouldn't, well, yeah, so artificial
Correct.
person is the second kind of person. Did y'all know that?
Yep.
Okay, so you have natural person. Can you give an example of a natural person?
All of us on this call.
Okay, let's see.
I'm making an assumption, but all of us on the call are natural, considered a natural person.
We got Brandon Man. I think Brandon Man might be a robot. But yeah, I think you're right. And I don't know, Warren, I don't know. Warren's a machine. Warren might be natural. But you're right. Yeah, everybody on the Quad, everybody on the call here are natural persons. Humans, like Quad is saying, those are natural persons. And the second type of persons are artificial persons, which are, can you give me an example of artificial persons? An example. You already did. Corporations, LLPs,
Right.
LLCs, all those entities, all your entities, whether incorporated, limited liability organizations, companies that are organized, those are all artificial persons. Okay, so those are two types of persons, not depending on anything. That's the definition of a person. And so I stopped there because I want you to make sure that this is not just Equifax. If they threaten to communicate this information to your cousin, anybody have a Pookie or Ray Ray? That's a person. I'm going to tell Pookie about this debt. So them threatening to tell Pookie or Ray Ray is just about as much of a violation of them saying I'm a threaten to tell Equifax, TransUnion, or Experian, or all the other reporting agencies. Okay, so that's why I want to just be very clear. I threatened to tell you your lady friend is at home. So that's why I wanted to stop on person. All right, let me do it again. All right, so communicating or threatening to communicate to any person, not just the ones that are consumer reporting agencies. You see that? Why I want you to read this very slowly and carefully. Any person, credit information which is known or which should be known to be false. All right. So either they know it's false or they should know it. So of course they can easily try to say they didn't know. But the part that we get them on is they should know. It should be known to be false, including the failure to communicate that a disputed debt is disputed. Okay. You got that? So that's E8. That's all of E8 right there. That's all of E8. That's a big money maker right there. E8. Anybody have any questions about the definition? The actual statute? All right. So again, communicating or threatening to communicate to any person, credit information which is known or should be known to be false, including failure to communicate the debt disputed. So E8 is a violation that can happen without you needing to do anything. The FDCPA does not require you to dispute something before it's a violation. So as soon as something hits your credit report, consumer report, and is by a debt collector, and it's information that they know or should know is false, you have a violation there. So this is something that can happen immediately. Now they give you so they give you an example, including the failure to communicate that a debt is disputed. Well, that doesn't happen immediately. That would require what? A dispute first. They can't fail to communicate that a debt is disputed before it's disputed. All right. So let's talk about that. Then we'll jump into the case. Okay, Quad, that's fine. Hope you feel better. So, including failure to communicate that a debt is disputed. So again, the first part of this doesn't require anything as far as you to do before you pursue legally. The second, the example, including, fail to communicate that is disputed, does require a dispute. Now, what I want to emphasize here is that a dispute here, the question is, what constitutes a dispute, or how do you have to dispute here for E8 purposes? Does it have to be in writing? Does it have to be certified mail? Does it have to be, can it be a phone call? The question is, how must you dispute here to trigger an E8 issue? Is it limited to something like we did C? We talked about C the other day, and we recognized that to cease and desist communication and collection activity, it has to be in writing. So is this another example of a dispute that has to be in writing, or no, it's not limited to just that? Anybody know? Is there a limitation?
It's not limited to that either or.
Yeah, I don't think it is.
Correct. It's not limited to the writing. Why? Well, first of all, it doesn't say it is. Okay, that's the tail sign. Those other statutes that say in writing means it's limited to in writing. This does not limit the form of a dispute. This could be by phone call. I don't know if Tony B's on here, but you can pull up to him. Like Birdman said, he was gonna pull up on the Breakfast Club. He didn't think it would be gangster. So you can pull up to him and walk in and say, look, this is not right. I paid this debt, or that's not how much I owe. So anyway, it can be in person, it can be by phone, by email, if they emailed you, by message, if they messaged you or texted you. Okay, so that's that. That's how that's, all right. So I'm about to jump out of the statute. Any question about the statutory language here and what it means?
Okay, Brian. Now, with number 8, okay, whenever you get a communication from a debt collector, and they say we may report this to the consumer reporting agencies, is that threatening to communicate at that point?
Okay. Yeah, I think so.
Okay.
Just think about it, someone calls us out, Parks, I may come over there and kick your butt.
Okay, makes sense.
That's a little threat. You take that as a threat, right?
Yes,
you don't know if they're gonna do it or not. You
exactly.
got to peek out your window.
Yeah, exactly. It makes sense. It makes sense.
Going to be as
Okay.
a mind playing tricks on me, peeking around corners.
Sorry, Brian, got bad connection.
I do.
I experienced bad connection as good.
Oh,
so.
you at the governor's mansion now. Okay, you fine now. Sacramento. Yeah. No problem. But yeah, that's a threat. I would say that's a threat. Threatening to communicate, because a threat, a may means it's a possibility. So that's a threat. Because when I change it to a threatening, like I may come over there and do something to you, you feel a little threatened. You might want to. You'll be looking at the cameras. So,
okay, so
yeah.
So when that language is in a communication from a debt collector, that automatically triggers E8.
Well, keep in mind it needs to be information threatening to communicate something they know or should know is false. So you got to remember there's other components. Okay. And it has the false part.
That leads me to my next question, is that the so-called account that's with the debt collectors, they should know that it's false, correct?
You can't just say it blanket like that.
Okay.
Yeah, you sort of, you haven't even established to me whether it's false or not. You're just saying they should know it's false. Well, you have to tell me that it's false, and
okay,
why would they know it's false?
Well,
or should they know?
they should know it's false with them because we don't have, the consumer doesn't have a, I want to say an account with them.
Okay, well, that doesn't make it false.
Okay.
And they're not saying it's with them. They clearly saying on a piece of paper they sent you or whatever they talking about you that it was originally due to them and we're just collecting on it or we bought it. So the fact that you don't have an account with a debt collector does not make it false. And they shouldn't be listing it on the consumer report like that either. So think it through, but no, don't revert back to those old things. Oh, I don't have an account with Midland,
I got you.
so it's false. No, they not. Midland's not saying that they gave you a credit card.
Okay.
So it needs to be more. It needs to be false. If you paid it, if it's obligation that you didn't do, yeah. So
I got you.
Yeah. So it has to be a reason, not just an emotional reason, but it has to be an actual reason that you think it's false.
Got you.
Mm-hmm. Anybody else have a question about the statutory language here?
Quick question, Brian.
Mm-hmm.
Say they reported to the CRAs without communicating. Do you have to have other options in place to trigger E8 if they never communicated and they just placed it on the CRAs without communicating?
That's a Regulation F issue.
Okay.
Okay, you familiar with when we talked about that? Regulation F. Regulation F, there's a no parking rule. You can't just show up at your door. They can't just come up to you. You know, it's no parking mean they can't just throw it in your credit without giving you notice about it first. So that's the first thing I want you to recognize is Regulation F, no parking rule. Tony V, there's a song that says no parking on the dance floor. That'll help you remember that no parking rule. There's no parking, baby. No parking. No, I think that's how it goes. No parking on the dance floor. Is that how it goes?
Oh man, I remember when that jam.
Oh man, I had to post a video in the WhatsApp. That's funny. Is that right? No park. Yeah, it's no parking. No parking on the dance floor. So, yeah, Anthony. So it's no parking. No parking at the decks on the consumer report without notice first. So if the first time you hear about that debt is on the consumer report, then you likely have a Regulation F, no parking, a parking violation. Okay. So anyway, that's the first part of the issue. The second part of your question was what? If they put it on there, what was the second part of your statement?
The second one I was asking in reference to the E8.
Yeah.
What would that trigger E8?
Okay, good question. So what triggers it when you look at that report and it says that you owe you owe Acme there's an okay, it says you owe Capital One $5,000 and you don't owe Capital One $5,000. Okay, that's false information, right?
Mm-hmm.
Now, why don't you owe Capital One $5,000, Anthony?
I have a contract or
Well, do you have a let me ask you this. In real life, do you have a Capital One card? You do?
Yeah.
Okay.
I have one.
Well, that'd be a bad example.
Yeah, I got one.
Had one. Well, do you owe Capital One money right now? You can decline the answer if you Anthony, if you want to.
Alleged that, yeah.
Let me go to another card. I'm sorry. Let's go to they put down that you have an American Express Black card and you owe $500,000 on that card. Let's do that example. Okay. Sorry to put Capital One on you. Okay, Anthony.
Okay.
So Midland Funding, they stopped buying these small cards. They bought American Express Black Card debt, and you went out and bought yourself, you know, something for $500,000 and just for whatever reason didn't pay. So that's where they're alleged.
Mhm.
Don't adopt those facts. So in real life, why is that a problem for you, Anthony? It's on your report. Is that false?
Yeah, that would be false
Why?
because they put the calculation of the alleged debt. That wasn't the original amount.
Isn't it deeper than that? Have you ever had an American Express black card?
Nah, I'm not in that group yet.
Okay, so there was no original amount. So you sort of playing with it. We talking real life.
Okay.
There's no original amount
hmm
unless you're talking about zero. So the issue is I've never had a black card. I'm not even in that. I was never invited to have a black card. That's the problem. Because I'm trying to get you to understand why should Midland know or should know that that's false. You've never had such a card.
Mhm.
And had they contacted you first, they would have known, right? Because you would have told them, excuse me. You got the my name is Anthony Wright, but you got the wrong person.
Okay. Yeah.
You see how I did that, Tony?
Got you.
All right. Y'all can tip the waitress on. Okay, you see what I'm saying, Anthony?
Yeah.
So anyway, yeah. Any other questions on that?
Got it now.
Okay, cool. All right, so let's look at a case. Let's jump into a case. But it's making sense, right? Yeah. Okay. This case is coming out of Georgia, which is the 11th Circuit in this federal court. This is a recent, this is from April of this year. Carla Leitner versus Cedars Business Services. Never heard of them. So we're going to run through this. Stop me at any moment if you have any questions. This is a report and recommendation on a motion for summary judgment. What that means is usually when you have a report and recommendation, that means a magistrate judge, which is the judge that works underneath the district judge, makes a recommendation to the district judge on how to rule on a motion. This is what you call a dispositive motion because that could end the case. It could end the case, a motion for summary judgment. So this is a recommendation to the district judge who will likely just basically adopt it, and this will be their ruling. And so I'm gonna read through this. So any moment that you don't understand something, just unmute and talk to me because I'm gonna be going through it swiftly. So the plaintiff claims that defendant Cedars violated the FDCPA by failing to report that she had disputed a particular debt. Okay, that's the whole case. So this is a very important statute. Just that violation alone can be an entire case. Both parties have moved for summary judgment. So what does that mean? Both parties want the court to decide on the case based on the evidence they have before them. And the action is before the court on these motions. The reasons discussed, the undersigned recommends that the defendant's summary judgment is denied and the plaintiff's motion for summary judgment be granted. What does that mean? Who's the defendant?
The Cedars.
And who was Cedars? If you can guess. A debt collector, right?
Right.
All right. And who's the plaintiff?
Of course, I forgot her name.
Carla.
Carla.
Yeah, a what? What kind of person is she?
Consumer.
Right, so I just want you to understand. So when it says defend, say it again.
I was saying consumer counselor.
That's right. That's right. All right. So the reason I stopped is because when it says the defendant's motion was denied, what does that mean?
It didn't accept it. It's denied. Turned down.
Oh, now.
The debt collector's motion was denied. They're trying to win the case. And plaintiff's motion is granted. So what does that mean?
They won.
Who?
The plaintiff.
The plaintiff, yeah, it's just one. The plaintiff won. Yep, that's right. So, okay, so just making sure. So here are the facts. Unless otherwise indicated, the court draws facts stated from the undisputed material facts, which are part of a summary judgment, where you state out the facts and you have to support it by admissible evidence, as well as so basically took facts from the defendant's statement of facts and plaintiff's statement of undisputed material facts, and defendant's response to their two where appropriate. Where appropriate, the court directly cites the underlying exhibits filed by the parties. Okay, the court must accept those facts admitted by each movement that are supported by citations to record evidence, which have not expressly been disputed with citations to record evidence. Local Rule 56.1, Northern District, is basically saying what they're saying. This court will deem each of the movement facts as admitted unless the respondent refutes the facts with evidence, okay? I'm not going to dig too deep into the procedure part of it. I want to get us into the meat, but basically, when you submit facts as undisputed and you have evidence, admissible evidence to it, if the respondent would be the other person. So if it's defendant submitting undisputed facts, the respondent would be who? The plaintiff. If it's the plaintiff submitting undisputed facts with evidence, then the respondent would be the, if it's defendant submitted, then the plaintiff would be the respondent. Okay, so that's that. So I wanted to boil down to that.
That's where those rules come into play.
Yep, that's where the rules come into play. So you have to know these rules. So and yeah, you have to know the rules. And you have to know all the rules because you don't know which ones you need. So you have to know the whole, you have to know all the rules. Accordingly, for those facts submitted by movement that the opponent has failed to dispute, the court must accept the facts as true. Okay, so that's basically it. And there's a citation to the case there. The court has nevertheless viewed all evidence and factual inferences in the light most favorable to the non-moving party, as required for motions for summary judgment. Meaning, any inferences will be in favor of the person that you're going against, that you're trying to get judgment against. The court excludes assertions of fact that are immaterial. Okay, blah, blah, blah. So we'll push through this because that's very procedural. But I gave you all this case. I'm gonna give it to you again. You can read closely. So Cedars, remember, the defendant is a debt collector as defined by the FDCPA. Okay, so when it says DSMF, that stands for Defendant Statement of Material Facts. So the debt collector has admitted to that, and also the plaintiff's statement of material facts, of course, have admitted to that because they obviously asserted or alleged their debt collector. During the relevant time period, defendant was attempting to collect a $2,473 debt that plaintiff allegedly owed to Walden University. Okay, small debt. Now follow these facts. This is where I want y'all to wake up. So this is the fact pattern. This is what's going on that you have to understand where the violation came in. As of November 5th, 2021, defendant had reported to the debt to TransUnion. All right. The defendant admits to that. And look at this. Plaintiff's November 5th, 2021 Credit Karma credit report. They call it credit report, but it's really consumer report. It's okay. Provided by TransUnion, indicating that the debt was last reported on October 2nd, 2021. Okay, let's review this. The As of November, the debt was on the Credit Karma. When they look at the report, it says it indicated the debt was last reported on October 2nd, 2021. Okay, y'all following that?
Yeah.
Mm-hmm.
All right. Now I haven't heard, and we haven't read anything about a dispute. We just know that we're looking at the Credit Karma on November 5th. This debt is on there. And when you look at it closely, it shows that the last report of it was October 2nd. Defendant did not report the debt as disputed as of November 5th, 2021, because as of that date, the debt was not disputed. Okay? You got that, right?
Yep.
So imagine
Yeah.
someone looking at it on the 5th of November. It's not reported disputed, obviously, because it hadn't been disputed. And that report had last been, that furnishing of that information was last on what date? When did the debt collector last furnish so far this information to TransUnion?
October 2nd.
That's right. That's right. That's right. All right. So cool. So now on November 18, 2021, plaintiff, now who's the plaintiff? We don't have to know her name, but
Consumer.
the consumer, yeah, sent defendant, the debt collector, a letter disputing the debt. Okay. And she sent it on the 18th. We need to figure out when they got it, right? Defendant received the letter November what?
22nd.
22nd. Okay. All right.
Can I ask a quick question, Counselor?
Yeah.
So does this apply to closed accounts? If you dispute something on a closed account and they don't mark it disputed, if it was charged off?
Well, this is a debt collector. Listen.
It's the original creditor, but still.
No. There's no but still.
Say that again.
I say it's no but still. I was just asking
Oh,
because
it's the original creditor.
so you tell me the answer to that because we looking at the what?
I mean, I would say it's the same thing apply. They trying to collect money, or they was at one point.
What
And
law?
if you,
what laws are you basing? What law are you basing this violation on?
Well, it would be it would be under E8 because disputed it and they didn't mark it as disputed.
And they is who again? Who is they? Who are they or who is them? It's a person.
Well, the company, Philadelphia Credit Union.
Oh, okay.
Mm-hmm.
Now, okay, so E8 is a part of the FDCPA, which applies. Would that apply to credit unions, original creditors?
No, wouldn't.
No. So the answer would be probably no. Not
Okay.
probably, but it's no. Now, some other stuff may, but not this.
Okay.
All right.
All right.
Okay.
Thank you.
Nothing wrong with that. So that's good because we need to make a distinction. You can't dispute your credit union debt and say, hey, y'all forgot to mark it disputed, because that's not how it works.
Because it doesn't cover under this one.
Correct.
Okay.
Correct. Now
All
all right. On the 18th, they sent, you're welcome. On the 18th, the consumer sent the dispute. On the defendant received the letter on November 22nd. And then they have a footnote, probably have a certified, let me see. Defendant does not, yeah. So the defendant does not dispute that it received the letter, but it states that it mishandled the letter internally. Unfortunately, the letter was not sent through the proper channels. Well, whose problem is that?
Yeah, yeah. Whose problem is that?
Okay. All right. Well, y'all need to get your TV channels fixed. However, all right, so they received the letter. They however, it continued. Now, who is it? That's the debt collector, continued to report the debt to TransUnion and did not flag in its reporting that the debt was disputed. Now, when they say continue, what do they mean? After, right? When it says continue, that's after they got it. Accordingly, plaintiff's January 3rd, 22 Credit Karma credit report provided by TransUnion, which indicated that the debt was last reported when? December 1st. Contained no indication that the debt was disputed. Well, so what problem do you see here? What violation do y'all see has just happened?
E8.
E8.
Okay. Let me see. What you drinking? What's on your desk, Tony?
It's one of those hot days here, if you know what I mean.
You don't have any vodka on it.
All right, Tony.
It's one of those hot days in here.
You don't have any clear liquid on it. All right, no,
Yeah,
E8.
absolutely.
E8. No, that's right. E8. Okay, E8. We just talked about E8. Oh man, look at that. So why are we in court? What's the problem? That's glorious. This is the lawyers just want to make some money. This is ridiculous. All right. According to plaintiff, as a result of defendant's failure to flag the debt as disputed, I've suffered loss of stress. Oh yeah, I'm stressed. Just think about it. Anxiety, loss of sleep. Yeah. Stomach issues. Yeah. Not GERD. What? Oh man. What is, I don't even, that's crazy. Anger, fighting with my family. See, it's not your fault. It's that failure, it's that undisputed notation.
Pile it on.
Man, y'all have to use, man, loss of, man, that's the truth. I have treated with my doctor. Oh, this is a quote. This is all quote. For the GERD, man, I'm taking medication to control it. Man, the defendant responds to this by stating the statement is not supported by any evidence other than plaintiff's self-serving declaration that contradicts. Okay, hold on. Can't. Well, it's her. She's experiencing this, so what other evidence do you need? A GERD meter? You need a stress meter? A stress test? Anxiety test?
Loss of sleep.
So Parsons, I'm trying to hit you today. But if I hit you and you say ouch, you can't just testify that it hurt. You gotta go to the ER to confirm that you hurt. Oh my gosh, man. Get out of here. Self-serving. Well, who else is gonna serve? Declaration that contradicts her sworn testimony. Okay, well, just because it's contradicted, what did she say? What's she gonna say? She got hurt? Well, anyway. Plaintiff's deposition transcript is devoid of any mention of her suffering from anxiety, a loss of sleep, and references. Well, if I ask you how you doing, Parsons, and you say you're doing fine, but you don't mention the fact that someone ran into you back in your college day, that don't mean it didn't happen.
That's right.
Hope nobody ran into you.
No.
Well, I'm just giving you an example. So just because you don't mention something doesn't mean it doesn't happen, right?
That's right.
Okay. Isn't that right, Tony? Anna? Yeah, Anna Velez? What's going on, Anna? Is that right?
Hey, yeah. Yep, that's right.
How you doing
I'm
today?
good. I'm good.
Yeah, but that don't mean that other stuff hadn't happened today. You know what I mean? So, all right. Plaintiff testified that the collection item had been removed from her credit disclosure. Disclosure? All right. which was better than a dispute notation. Well, I got a feeling it wasn't removed. Okay. Well. All right. Plaintiff testified that she did not know if the amount on her security deposit on her new apartment would have been less if the collection item had been marked as disputed. Okay. I'll mute you, Wesley. All right. My volume's still good. Testify good. Plaintiff testified that she suffered from GERD previously and that she had flare-ups irrespective of the issue with Cedars. Well, like I said, back to Parsons. I mean, using this punching bag. So I hit Parsons and it hurt. So he never hurt before in his life. I mean, so just because he was hurt already, when I'm hitting him, or say he already hurt his left side, and I hit him on the left side, it don't mean I can't hurt his left side. On top of that, hurt. So again, that's logic. So irrespective of Cedars, she's had GERD and flare-ups, but for some reason she thinks this contributes to the GERD. So basically, you don't have to be perfect. What they're trying to say is, oh, well, you weren't perfect before. You had stress before, so it doesn't mean, as if to say you can't have additional stress by what happened to her. All right. The court, however, is obliged to accept plaintiff's statements in her declaration, self-serving or not. That's right. That's right. For purposes of resolving defendant's summary judgment. That's right. That's her statement. I like that. That's a good quote. 11th Circuit. Keep an eye on 11th Circuit. Here's a case saying that plaintiff's self-serving affidavit to be sufficient evidence both to establish injury for Article 3 standing, okay, and to raise a jury question about damages on the merits. All right. Feliciano versus City of Miami Beach. You been in Miami Beach, Tony B? He enjoys California.
I'm in South Beach.
Yeah. So Tony B knows about that. Plaintiff's sworn statements are self-serving, but that alone does not permit us to disregard them as summary judgment stage. Of course, it's self-serving. That's why affidavits have to be what? From personal knowledge. And if it's about yourself, that's even better. You can't do an affidavit about someone else. Furthermore, some of the testimony cited by defendant that the debt ultimately being removed at the price of the security deposit is plainly irrelevant. It is. So just because it later got removed and not knowing about the security deposit, that's irrelevant because before it was removed, it wasn't. All right. Similarly, although plaintiff did not specifically mention anxiety or loss of sleep at her deposition, that is not contrary to her declaration. Like I was saying earlier, she generally testified that she suffered from stress, and these symptoms may have been a manifestation of that stress. Okay. Anxiety. So stress leads to anxiety. Stress leads to loss of sleep. So, okay. So, yeah. So anyway, to the extent defendant suggests that plaintiff testified that her stress was only related to moving and not related to fitness conduct is not supported by the record. So basically they're lying. They're trying to say that she pinpointed stress just to moving. That's clearly not supported by the record. That's what the court means by that. At plaintiff's deposition, defense counsel and plaintiff had the following exchange. All right, defense counsel and plaintiff. So this is a deposition where the debt collector's attorney is deposing the plaintiff. So you understand, the Q stands for question. Who's asking the questions?
Attorney.
All right, and then who's answering?
Consumer.
That's right.
Consumer.
Okay, paragraph 14 of the complaint says you suffered pecuniary and emotional damages. Do you see that? Yes. Can you tell me what that's about? Yeah. It was just really stressful during the time, mainly because, as I stated, I was moving. You see how they twisted those words?
Mm-hmm.
It's not that the stress was from moving, it's extra stressful because it was around moving time. Anyway, well, I was preparing to move. I knew the end of my lease was coming up, so I was trying to get these things reconciled. So this person has to move, but they have, you see people with a collection, you're going to get denied. So you're stressed. You're like, oh my God, I'm not going to be able to get a place. So you see how these lawyers want to twist her words. This testimony is not inconsistent with plaintiff's statements in her declaration. Finally, the plaintiff may have had some GERD flare-ups unrelated to defendant's conduct does not mean that she did not also suffer GERD flare-ups that were related. You see that?
Mm-hmm.
This is common sense. You see what I'm saying? This is how you have to think. This is how this judge is really, catching this. And in fact, her testimony suggests that was the case. You go to 2. You go down to 2. Talks about some questions. Okay, I'm not going to go through that. Plaintiff filed the lawsuit on January 28th. After she did so, okay, so the lawsuit was filed January. This person moves fast. After she did so, defendant reported the debt is disputed and submitted a request that it be deleted. Okay, so that's after.
Mm-hmm. After the fact.
Okay. That's after. Okay. So we talked about Parsons' car getting hit from the back. So just because Parsons, whoever hit the car goes and gets it fixed and all this stuff, but he still has that injury. If he was in it, right? That doesn't make the violation go away. Just because you deleted it and marked disputed, then deleted it. Okay, so that's a fact pattern that I wanted y'all to see. We're gonna slide down. Like I said, you can read this summary judgment language later. It talks about procedure on the summary judgment. But I want y'all should read it. But I want to go down. Standing. The defendant argues she doesn't have standing because she hasn't suffered. She did suffer injury. In fact, she suffered. We listed those injuries that she stated. So she says she stayed from the stress, the loss of sleep, stomach issues. Those are all personal injuries. Okay, and so the court finds the 11th Circuit has recognized that emotional injuries like plaintiffs can constitute injuries in fact. Okay, now some areas don't recognize emotional injuries, but remember when they say emotional injuries, they're not talking about that stomach stuff. The GERD is a physical injury, but they recognize it in 11th Circuit. So the court recognizes she does have standing. I'm trying to see if they talk about the fact that she has those stomach issues. So the court, I guess, stopped there because those emotional injuries were sufficient. So they didn't talk about the physical manifestation. Like the GERD and the other injuries, those are not emotional. Those are actual physical manifestations. But I guess the court stopped there. Now, you see in the 7th Circuit, the courts found that stress with no physical manifestation does not equate to concrete harm. So you have to really figure out what court you're in. So not knowing, if you don't know the difference between what circuit likes it and not, be sure to try to identify any physical manifestations. The GERD and things like that, those physical.
Hey Brian, can I ask a question real quick?
Mm-hmm.
In regards to standing, if you are in the 7th Circuit like I am, should you just file it in state court and let them waive it or I should say move it to federal court so they can argue with themselves about standing?
Well, I mean, you're asking me something that I've taught every week. Yeah. I've always said it over and over. Yeah, file the state, let them pull it. And now they're asserting you have standing as soon as they remove it. The standing is actually there. They have to say, you know, they're basically admitting, but now they can remove something and you still may not have standing, but yeah. But absolutely, I agree with you. Yes, that's what I've been preaching that for a good moment. But yes, absolutely. The plaintiff's FDCPA claim. Okay, so we're gonna talk closely about this. The parties disagree as whether the plaintiff has satisfied the elements of an FDCPA claim. Okay, so now we have the standing. Now, is there an FDCPA claim? All right, well, I'm going to scroll down a little bit. It talks about what FDCPA is to protect consumers. Okay, y'all know that. To prevail on the FDCPA claim, these are elements. Elements are the consumer has to be an object of collection on a consumer debt. 1, 2, the defendant attempting to collect the debt has to be a debt collector. 3, the defendant has engaged in a prohibited act or failed to perform something imposed by the FDCPA. All right. So 1, 2, 3. Consumer being an object of the collection of a consumer debt. You have a debt collector. You have a violation. Okay, those are the elements. Here, in this case, only the third element is in dispute, whether they did something wrong. Okay, so that's what they will focus on in this case, on this summary judgment motion. The parties dispute whether they violate 1692E, and specifically E8. Let's scroll down. According to plaintiff, defendant violated. Now, what do y'all think? It's clear, right? What are you talking about? What y'all talking about? Crazy. According to plaintiff, defendant violated this provision when it reported to the debt to TransUnion without flagging it disputed, despite having received the dispute letter. Y'all agree with that, right?
Yep.
As the basis of his motion for summary judgment,
Yes.
defendant, what? Yeah.
I was saying yes, Counsel.
Okay. Defendant relies on the FTC's 1988 staff commentary on the FDCPA and a series of other cases to argue that because it had been reporting the debt without a dispute, it was disputed, it was free to continue doing so after the dispute. That's they crazy. Y'all crazy. Okay. First of all, a lot's happened since 1988. Knuckleheads. So dumb. Okay, as displayed below, this is not a fair reading of the FTC commentary. Even if it was, you might want to update your calendar, don't you think? Knuckleheads. What knucklehead? Regarding the relevant provision of FTCPA, the FTC commentary. Now look at this. Look at the commentary. This is the commentary they're referring to in 1988. And let's see how dumb they are.
I couldn't find a recent one. Or is there a recent one?
If they haven't changed its position, maybe not. Disputed debt. If a debt collector knows that a debt is disputed by the consumer, either from receipt of written notice or other means, and reports it to the credit bureau, he must report it as disputed. All right. And of course, they don't know what they're talking about. But post-report dispute, okay? Consider this to be when they're reporting it initially or something like that, right? If they know it's disputed, they have to report it. All right, post-report dispute. When a debt collector learns of a dispute after reporting the debt to a credit bureau, the dispute need not also be reported.
But this one doesn't apply.
Well, you say it doesn't apply?
Doesn't apply. Number 2 doesn't apply. This is a wrong. This is not an accurate comment to make on this case.
Okay, well, you have to,
Because it says after after reporting, right? This is
Mhm.
yeah. I mean, they
so
received the dispute, and then when they reported, they did not mark it disputed. So this number 2 doesn't apply.
okay. So it's like using your blinker. If you are not turning or changing lanes, you don't have to use your blinker. Or
It looks like
or let's say this. If you're changing lanes, number one says if you're changing lanes or turning, you have to use your blinker. Okay. 2 says if you're not changing lanes or turning, you don't have to use your blinker. So you're saying it doesn't apply. 2 doesn't apply. Well,
what I mean is that that's not a good reason. This is not relevant.
okay.
That collector is wrong making those argument number 2. That's a bad argument they're making. That's what I meant.
Okay. So I'm going to say that this 1988 advice still is good, but you have to read it and think of and read it and pair it with what's happening with this debt collector, because what you all may be doing is thinking that this debt collector has the debt, reports it once, and never communicates with the Consumer Reporting Agency again. Is that what y'all are thinking?
No,
Because let's think about it. Okay, let's think about it. You remember the facts of this case. In November, that debt was already reporting, wasn't it?
November the 5th, wasn't it?
Yeah,
18 was 22nd.
whatever it was, November 2nd.
Second, okay.
Yeah, they received on 22nd, November 22nd.
Right. But I'm saying that when she looked at that Credit Karma before she disputed it, the debt had already been reported
Right,
to
Correct.
TransUnion.
Yeah, that was the 5th.
right.
Okay, yeah. Now, so it had been reported. So when she disputed it, it was a post-report dispute, correct?
Right.
Oh, all right.
Okay.
Right, because it
Oh,
was
okay.
yeah,
Because
because it was
what?
already on her. It was already
yeah.
on her report.
So when she okay. So when she disputed it, it was a post-report dispute. So what does the debt collector need to do at that moment, at that particular moment?
Well, they need to report it to the market as disputed. That's what they have to do.
No, they don't.
Deleted.
No, they.
No.
Well, that's not what the FDCPA says.
Well, all right. Well, we're about to. This is why we're on this call, because
Explain it.
what
Right.
happens is they don't have to, according to this post-report dispute, they don't have to. Remember, it says when a debt collector learns of a dispute after reporting it, the dispute need not be reported. Meaning, at that moment in time, just because you disputed it, and this is why we're having this call tonight, is because this is the twist. This is the twist. This is the end of the movie on Netflix. You got like 20 minutes left. You know what I mean, Tony B? You hooked on it. You know what I mean?
Yeah.
This is the Netflix. Those Netflix movies, man. They shoot. Yeah. What? You seen the one where they that kayak and that one guy was a killer. Anyway, all right. The debt collector doesn't have to do anything. Now, I'm gonna scroll back up because my memory is a little tricky. All right, check this out. Let's scroll back up. Okay. All right. November 5th, when she looked at it, last report, October 2nd. On the 18th, they sent that letter, November 18th, They got the letter on the 22nd. She looked at the report on January 3rd and saw that the debt was last reported when?
December 1st.
Okay, so reported by who?
The debt collector.
On December 1st. And they got the letter when? November 22nd.
Second.
All right, let's go back down to the FTC, 1988. I was 10 years old. Man. Let's go back to the FTC. Okay. So now the debt collector is going, we have to go back to which number to see about what's going on in that. Well, I forgot the date already, but anyway. She looked at it in January 3rd, but it was last reported, what, December 1st?
21st. I'm sorry.
Huh?
December 21st.
Oh, okay. Is that right? Okay. So now, Tony V, it looks like we're back here because they're doing a report again. You see what I'm saying? You see what's happening? So instead of sitting on that report, they've updated. They have a system that's going to report again. So they started over. But now what's different? They what? They know that it's disputed. And so what must they do?
Market as disputed.
Does that make sense? Here's another question. So you got that? That's a little tricky. We're almost at the end of that Netflix movie. Be sure to pause it if you have to use the bathroom because you don't want to miss anything. You know what I mean, Tony? Yeah, pause it. Okay. What I want to show you. December 1st. You thought it was 21st. What's different on December 1st when the debt collector reported it as TransUnion? What's different than back when they last reported October 2nd, 21? What's different?
They received a dispute from
They know it's in dispute.
Yep.
And so what must they do different now?
Market as dispute.
Got it. Now let's change the facts. Let's act like the new facts are after October 2nd, the debt collector never re-updated or retransmitted that reporting to TransUnion. You got it? But everything else happened. They just she disputed it. They got it on the 22nd. And she looked at her report on January 3rd. The debt is still there, the collection. It still shows last reported October 2nd, 2021. Is there a violation under E8?
Oh,
All right, Tony V says no. That's on the West Coast. What else we have? What about in Pittsburgh?
the reason I'm saying no, Brian, because
no. Hold on for the reason. Let me get to the other
okay,
votes.
sorry. Yeah.
1 second. What are we saying, Pittsburgh?
I go with Tony. No.
All right, so you got the Steelers saying no. No violation. And I want to hear your reason, Tony. I do. I'm just trying to get the other votes. Anybody else? Is there a violation under E8? Remember, I changed the facts. You remember? Okay, so is there a violation? Anybody else? All right, so Tony, why do you say there's not a violation?
Oh, I mean, the reason is because even though the defendant received the dispute, they did not update update it with they did not update the reporting with TransUnion.
Right.
So, and we covered this. We had another case. I
We
think
did,
we
we
covered
did.
similar situations like this maybe like a couple of months ago. So, and they in that other case too, the defendant used this FTC 1988 ruling, which was incorrect. Yeah, because if the debt collector receives a letter that the consumer disputes, next time, if they update it, they have to mark disputed. But if the debt collector chooses not to update it, they don't have to mark it disputed.
That's correct, Tony B. Thank you, Tony B. Oh man, that's excellent the way you describe it. So that's correct. This is the trick. This is the trick here. And this is the trick. You have to look at that last updated, because if they don't update, that old FTC still applies. Now there's case law that says this, and here's one, this is one, and there are others that reiterate this, but this is how it works. Each time you report it after knowing about the dispute, now you're in this number one category. You must report it as such. All right. So that's correct. So that's the special sauce today. So citing the commentary, a number of cases have held that debt collectors who receive a dispute about a previously reported. This is what I've preached to y'all before. The debt collector does not have an affirmative obligation to report that dispute after receiving it. Does that make sense, or does that seem counterintuitive?
That makes sense after going over what we just did.
They don't have an affirmative obligation means, what does that mean? All
They
right.
don't have to do it, basically.
They don't have to just jump because you disputed it and run and tell TransUnion it's disputed. No. However, what's the twist to it? This is the end of the Netflix. If you do report it,
if they
you
update,
do.
yep.
That's right. That's right.
Yep.
So there's no affirmative duty. So that's what it means. There's no affirmative obligation to report the debt after receiving it. Of course, you have to read. But if you do end up reporting, you have to mark a dispute. So from this, defendant extrapolates that because it was not reporting the debt as undisputed before, it was free to continue to do so after. No, no, no. This is not a fair reading of the commentary. It's retarded. I mean, I'm not sorry. I'm sorry to offended. But,
No, you had it right.
But we have guests.
Okay.
Hey, Brian, would it, to shore up a case like this, it would probably be a good idea to maybe just call the debt collector and say, hey, how often do you guys report to, the credit reporting agencies? And I would say probably record that phone call, and they may say, oh, every 2 weeks, every month. Would that lock in the case if you were to present that recording as an exhibit in this?
How would it lock it in?
Because they're going on.
It doesn't matter when they say the report. What matters? What really matters?
Okay, got it. Okay, if they updated it or not.
Yeah.
So,
if they report,
all right, never mind.
What they say is
all
what
right.
they do.
All right.
All right. All right. No problem. No problem. It's we here to talk it out. We're here to talk it out. This is not a fair reading of the FTC commentary or the cases that rely on it. While a debt collector does not have to proactively, what's the word for proactively? Affirmatively. It doesn't have to just run just because you dispute it and communicate. A debt collector does not have to proactively communicate to anyone that the previously reported debt has subsequently become disputed or amend an already issued report for that purpose. This is very important. That does not mean that it is free to omit the fact that the debt is disputed if it chooses to make new reports about that debt. Woo! Isn't that cool? So it's important to know. In other words, if a debt collector learns of a dispute, it is free to stay silent, even if it has previously reported the debt. However, if it decides to communicate about the debt after dispute, it must communicate the debt is disputed. All right.
It tells you what to do right there.
Yeah.
What the deal is.
And this is what I've talked about. A debt collector does not have an affirmative duty to notify CRAs that a consumer disputes the debt unless the debt collector knows of the dispute and elects to report to the CRA. Okay, that's what I talk about. Like, you hear me say affirmative duty. And you saw above, it's talking about affirmative obligation, same thing. If a debt collector elects to communicate credit information about a consumer, it must not omit a piece of information that is material, namely that it's disputed, okay? Accordingly, a number of courts in this circuit have found that a debt collector violates E8 if it reports a debt to a credit agency, learns of a consumer reports, then reports the debt to a credit agency again without disclosing the dispute. You see that? 2021 case, 2019 case, 2020 case, 2017 case, all right? Rejecting the argument that he had no obligation to report a dispute after receiving a dispute, where allegation was that defendant had affirmatively re-reported. Okay, y'all got it? I think you got it. I think y'all got it. And y'all can read through this other stuff, but I think y'all got it. Let's see. Okay. So let's go to, all right, so anyway, defendant's motion is denied. No, y'all ain't getting them. Bonafide error, let's talk about that. They're saying, oh, my bad. Bonafide error. It comes from 1692 KC. Tony B. KC is one of the members of Jodeci. So you can go YouTube, you go to Jodeci. It's a KC JoJo. I think Devontae.
Yep.
So you take a look at it. This is Jodeci, Jodeci. You could do Stay or some good song. You could do a lot of songs. Which provides that a debt collector may not be liable if they if by preponderance of evidence show that the violation was two things: not intentional and resulted from a bona fide error. But three things: notwithstanding, they have to have maintenance. They have to maintain procedures reasonably adopted to avoid that kind of error. So really three things: not intentional, and it has to result from an error, and they also have maintained procedures reasonably adapted to avoid that kind of error. It is an affirmative defense for which the burden of proof is on the debt collector. All right, let's look at this. The debt collector, to do that defense, they must show that it was not intentional, like I was showing you. Oh, just like I said, you see that? Bona fide error. And three, it occurred despite maintenance of procedures. Got that? That's what we just said. The failure to meet any one of those requirements is fatal. That means it kills that defense. Supreme Court has held the bona fide error does not accomplish mistakes of law or misinterpretations. That means when they think they're not doing anything wrong, but they are. That's not what that's for. Instead, it protects for liabilities for errors like clerical errors or factual mistakes. According to the defendant, it satisfies the elements. First, the violation was not intentional, as Cedars had no knowledge of the dispute initially. No one cares about it. What are you talking about? And no duty to update. What are you talking about? That's weird. They're dumb. And no duty to update the data furnished with her post-report dispute. But that's ridiculous, because we just read that they updated the report. Second, to the extent a violation occurred, it resulted from Cedars' good faith mistake with regard to plaintiff's dispute of the subject debt. Third, any unintentional violation occurred despite their maintenance of procedures. Well, all right. The undersigned has already determined that defendant's position that it had no duty to update post-report is contrary to the law. So they've done a mistake of the law. So that's not a bona fide error defense. So defendant's only argument with respect to the first element appears to be it's erroneous reading of the FDCPA. Well, so is that bona fide error? No, because it doesn't cover mistake of law. However, the Supreme Court precedent makes clear that the bona fide error defense is not available to defendants who make mistakes of law or misinterpret the FDCPA. We just read that, right? So therefore, the defense affords no protection here, because the undersigned finds that the plaintiff has standing, the elements of her claim are satisfied, and the bona fide error is inapplicable. Is recommended that her motion is granted. She wins the case, all right? So I gave y'all that case, all right? So that's that. That's just as a nod. I think I've done the case before this. How you like that case?
It's a good, very good case.
Oh man,
Love
y'all feel?
Love it.
Anybody's brain feels smarter after that one?
Yes, sir.
Man, your brain should be tingling. That's good.
That's very good.
What guests we have? Y'all been to church where they have the guests stand up. What guests we have? Unmute yourself if you're a guest and let us know how you doing. We already talked to Aaron.
My name is Vernay. I'm sorry. Thank you so much. I came in on the tail end of this, and I just want to say thank you. I have a lot of respect for you and what it is that you do, and thank you so much. This was very helpful and very insightful for me, for sure.
Oh, you're very welcome.
Always a student.
You're very welcome. Thank you. And anybody else want to unmute, you got to have respect for them. If you don't like me, don't unmute. If you're a guest. Any other guests? Okay. Yeah, thank you, Renee. And by the way, we do this every week. It's called Credit Masters. So you can message me if you want to have access to this. This is just
Absolutely. Thank you.
This is one of over 100 lectures that's available with materials and files. So okay. All right. So any questions about this case? But great case. Great case. I gave y'all this case already, but I'll repost it so you can save it and be sure to save it. But that's a great case that really opens your mind up to understand E8. So I want I think y'all got it, and it's good that we talked about it, because now that you have it, you really understand E8, because people are not going to understand. They're going to say, I disputed it and I checked my Credit Karma the next day after they got it and it's not marked dispute. I'm going to sue. You see what I'm saying?
Wrong.
No. So anyway, we're gonna do open Q&A just for a little bit. If you have any, we didn't have any submissions, I don't think, but anybody have any open Q&A? And for the guests, open Q&A is where you can ask a question. It doesn't have to be related to what we talked about just now. It can be about anything consumer law related. I'm not a veterinarian, so if your dog is spitting up, I can't talk about that. But anything about consumer law, open Q&A, go ahead.
Quick question, Brian, in reference to the case.
Mm-hmm.
When it comes to Credit Karma, would that be a reliable source to use in a lawsuit, or MyFICO?
Too hard on you, but we just read a case where it was. So that would mean that it certainly can support a case. But the answer is yes. So because it is a consumer report.
Now, the reason why I also asked that is because I heard through the grapevine that don't use Credit Karma, use annual credit report consumer.
Well,
So that's why I asked that question.
All right, so I wouldn't eat those grapes, wherever grapevine that came from.
Oh, it's sour.
I don't care how many times you rinse it off. Baking soda,
vinegar.
I don't care. I don't know what grapevine you. Tony B, did you have one of those little grapes from the McDonald's? Your Parsons did it.
Yep.
But Brian, there's a lot of stuff out here.
Well, that's why you're in here. You gotta stay inside. But okay, so here's the thing. I'm gonna tell you this. What you learn here, you should be able to go outside into the wilderness and know not to drink
poison.
Eat every grape you see. You should be able to look at it and examine it and see if it's good or not. Okay, so that's why you're here. Yeah, it's a bankruptcy. You got a bankruptcy case. Does that make sense, Anthony?
Well, yeah, it makes sense when you clear it up.
But
then,
yeah. But as far as Credit Karma is superior to use than annual credit report, because annual credit report is a disclosure. It's not a consumer report. So yeah.
All right.
Yeah, so good question, Wesley.
Yeah, no, I think you cleared it up because I asked a similar question, or it's not the same question. I think.
Okay. Rhoda Marie had a comment, submission on the comment says, in regards to bankruptcy dispute, what are the next step after LexisNexis verifies and states their source is Pacer? Is there a bankruptcy package available? Well,
You said yes, or what? What was the answer?
I didn't say answer yet, but the next step would be there's a bankruptcy deletion letter package, so you can follow that package. But on the basic level, that's a CRA dispute. So if you have a CRA dispute that comes back verified, there is a letter 2 now in the CRA dispute process. But yes, you can either letter 2 or you can litigate, if it's improperly verified. And there's a bankruptcy deletion package. And you can just message me. I can give you a link to it, that particular package, because they surely don't get their. Well, I'm sorry. LexisNexis does get their stuff from Pacer, but it doesn't mean that their reporting of it is accurate and complete. So them saying who their source is does not protect them from dealing with the dispute of the accuracy and completeness. Okay. Wes, you got the answer?
No, I was just asking and verifying. I think you said it. The my understanding, unless you tell me I'm wrong, can I move along so other people can ask their questions? But my FICO, that is a yes with a credit report, with actual credit report.
Yeah, my FICO produces consumer reports. Yep. And so does Credit Karma. Those are considered consumer reports as well, because it's coming from like a CRA to a third party.
CRA to
but my FICO is superior because my Credit Karma does not give you all reporting agencies, and it does not. It's just not a comprehensive thing. But if that's all a person has, that's fine. That's fine. You can actually use it. And remember, if it says it was last reported, then that's all you need. Like this case is a prime example of how the Credit Karma is just fine.
Right.
But the my FICO is just more extensive, gives you scores and things.
Okay. Cool. And one more thing. And it's just another joke. When realtors deal with people and they pull their reports or consumer reports and everything, do they go through the same method as far as using third party reporting, or do they have like a special portal or tool they use because they're realtors?
Can you spell realtors for me?
Nope.
Okay. They usually go through third parties, companies that provide a report. Or they may have but usually it's a third party situation.
They usually go third party. Okay.
Mm-hmm. Even if they went to the reporting agency itself and the reporting agency sent a report to the realtor, what would that be called? That's a consumer report.
Say that. So hold on, say it again.
What if the realtor or realtor, depending on who said, what if they went to the consumer reporting agency like Experian to get a report of that renter? for example. I was saying, what would that document be? Would it be that document goes from the CRA to the realtor company? What would that document be? Would that be a disclosure, a file, consumer file, or a consumer report?
Great question. I will say that might be disclosure.
Why would you say that?
No.
I guess.
God. Yeah, well, now think about it.
What's a disclosure?
Yeah, disclosure, that's basically it'll disclose the information, but it's not thorough. It only give you um not bits and pieces. I say probably 80% or 70% of the information needed. It's a disclosure statement. It only, in my head, how you gave us the definition, it only prints out like half of the story or bits and pieces of the story.
Okay.
It's not a full report. A report that gets granular. That gets granular and shows all of your transactions and everything, and it basically fills out a report or actions that the consumer has done. And I'm not gonna lie, in the file, I forgot what the file. It's not coming to me. You said the file. You gave us definition of file, but that's not coming to me. But you can go ahead and grill me and take me apart and all that. But info help. CRA.
Okay, so which one of those apply here? The snare just gave you said it's coming from the CRA to the realtor. Okay, so you got CRA. Okay. So just going from the CRA to the realtor, which one of those? Let's see, let's do 1, 2, and 3. 1,
Yeah.
2, 2, or 3. Like an optometrist. It's coming from the CRA and going to the realtor, or if you're an Atlanta realtor, what they have out there, parts? Realtors or realtors?
Realtors.
Come on, Wesley. All right. Well.
Okay,
let's do process elimination. Which one has a CRA going to somebody? 1, 2, or 3.
Well, number one.
Just number one.
Or you say going to somebody. So, I could pick more. Number one and number 3.
All right. So we limit number 1 and number 3. All right. Number 1 has a CRA sending it to the consumer. Is that applied in this scenario? Is it realtor?
No.
Oh,
no,
okay. We'll eliminate that one. So number 3 has a CRA sending it to a third party. Is that sound like it apply? Is it realtor a third party?
But I have a question, but no, I'll say no.
Go ahead. No. What's the question? What's the third party?
Well, I guess where I got stuck because I'm thinking in my head, like, okay, a realtor, like what are they like defined as? Like, because if they step to the, CRA, they have to be defined as something or be able to have permission or be able to go to them and have access to get that. And so I don't know what they're considered as or what they are looked as, or what does the CRA look at them as?
Look who as?
The realtor, yes.
Well, we know realtor's not a consumer, it's a third party. So they
Okay.
get a report. So it's called a report. So all I'm saying is, what if the realtor gets it from a company or directly from the CRA, it's still a consumer report. That's the moral of the story.
Okay. Okay. So the answer is report. Okay. Hold on. What happened to your screen? Okay, there it is.
Okay. Well, and Tony V reminds us that LCI is reporting a TransUnion on those bankruptcies, public record bankruptcies, with respect to bankruptcy. LCI stands for idiots.
And LCI is a consumer reporting agency.
Yeah, it depends on what day of the week you ask them, they might.
Yeah.
All right.
And Brian, one thing I think what popped in my head is I remember you were saying, and I think in the lawsuit, I mean this case that we just did, reports need to be leveraged and used in cases and not disclosures. Right? Like in her case, she used Credit Karma. That came out. That was an actual.
Yeah. You can use a disclosure, but it's only for a reinvestigation 1681I violation.
Oh, okay. It's for a
so you can use it, but it's just limited.
Okay.
For failure to investigate, you can't like she used this for the anxiety. It's an FCRA case going against the CRA. Yeah, if you use a disclosure, your only problem can be a reinvestigation issue, and not that they sent that somewhere, because disclosures don't get sent to third parties, so you can't use a disclosure for anything but a 1681I reinvestigation issue. So to avoid all the complex analysis, you just best to rely on reports, consumer reports.
Yeah.
Okay.
Yeah, I'm tracking. Appreciate it.
All right. Yeah. All right. Well, we're going to wrap it up, and thank you for everybody, the guests. We have some guests. I'll post. I may put this on YouTube and have a link on how you can join Credit Mastery for those of you across the United States that want to learn and feel your brain tingle like this every week.
Yes, sir. Yes, sir.
Why should they join, Parson?
Where you can learn to get the knowledge to be powerful. You can do damage.
Oh, that's
with the right knowledge.
Who's that? Summer Walker? Who says that stuff? That's SZA, I think. You can do that.
Yeah.
But I think it's SZA. But anybody else have any other questions? Q&A side? Guests, anybody? Students, everybody? Who else? All right, give me another guest. Tell me another guest. I want another guest to come on. Tell me how they like to, if they learn something. Don't be shy. Nobody's gonna bite. And let us know where you're from. And we're gonna let you go. We're gonna ask you to join the church or anything like that.
Come on, y'all.
Anybody? Who we got? All right, y'all shy. Y'all warm up later. But okay, any other Q&A questions? All right, well, thank you for joining. We're gonna wrap this on up. And for those of you that have missed it, it'll be re-uploaded and you'll be able to see it and review. And if you want a copy of this case, and if you're not in my group, you can just message me and I'll send you a copy of that case. All right, everybody have a good evening.
Cool. Appreciate you, brother.
Very well. Bye.
Peace.